Good afternoon. This is attorney Elise Gross with the Presser Law Firm. Today we're going to be speaking about the Secure Act and what you need to know about IRAs. Before we get started, I just want to go over a couple of housekeeping details. If you need to reach out to us, please email us at info@assetprotectionattorneys.com. We're going to, I believe, post the phone number to log in the chat box, and you can chat any questions you can type in. I'll try to get to them, but sometimes it's a little bit distracting. So if I can't get to them during the webinar, we will send you an email response. In addition, if you're not already receiving our weekly e-newsletter, please let us know and we'll be happy to get you on the list for you to be receiving them. We also do complimentary preliminary consultations, so give us a call or send us an email and we'll be happy to set that up for you. And lastly, we have speakers in our law firm who have been speaking all over the country for years and have a lot of experience and will speak on asset protection and estate planning topics. If it's something that you're interested in, please contact us and we will set that up for you. My name is Elise Gross. I am an attorney. I've been an attorney in South Florida for over 25 years, practicing in the areas of estate planning, asset protection, and probate. I'm also an adjunct professor at Florida Atlantic University, where I teach the paralegal students on estate planning. Today we're going to be talking about the Secure Act. The Secure Act was passed at the end of 2019. We'll be dealing specifically with IRAs and how the Secure Act has changed IRA rules, how it contrasts the rules with the eligible designated beneficiaries, how it works with special needs trusts, what estate planning needs to be revisited, and what are some of the planning options. So what are retirement plans? I'm only going to spend a moment or so on retirement plans in general. Generally, they are ERISA qualified plans, federally qualified plans. They might be 401ks, they might be defined benefit plans, they may be 403bs, depending on who your employer is. And then you have the IRAs, the individual retirement plans, which are basically separated into the simple and the traditional, which are pre-tax IRAs, meaning that when you contribute to your IRA, you do it before you pay tax on the money, which means when the money comes out, it is going to be taxed. Contrast that with the Roth IRA, which is post-tax dollars, so when the money comes out later on, there's no income tax on the money and on the withdrawals. So those are two very different types of plans. The rules that we're going to be talking about today in the Secure Act generally apply to both of them. However, there are different implications to the simple and traditional and for the Roth. So what is the Secure Act? Well, it stands for Setting Every Community Up for Retirement Enhancement Act. It was passed very late in 2019, but with an immediate effectiveness for January 1, 2020. So what we're going to be talking about today does not affect plan participants who died before January 1 of 2020. It will only affect those who died after January 1 of 2020. And there's some key points that have major effect, so it's important to make sure what the date of death is. And when I use the word participant, that means the person who set up the IRA. So what are the key changes? Well, the main one, which is causing the most amount of buzz, is the fact that there's an elimination of the stretch IRA, except for people we're calling eligible designated beneficiaries, or I may refer to them along the way as EDBs. The idea behind eliminating the stretch based on Congress is they want to be able to move money into the economy sooner. Whereas if you were stretching the IRA, then it was taking a very long time for beneficiaries to take the money out and therefore pay the income taxes on it. So now, when you eliminate the stretch, there's a requirement of getting the money sooner, and therefore income taxes are going to be paid sooner. Obviously, this is not going to apply to the Roth IRA. This is only going to apply to the simple and the individual IRA and the simple IRA. There's also an increase in age restriction. So what it used to be is that you weren't allowed to be taking your IRA without penalty before age 59 and a half. That's still there, but you had to make your first withdrawal and start taking required minimum distributions by age 70 and a half, and that has actually been expanded to age 72. So that's a nice little increase. I've also been told that the life expectancy tables have also increased by about a year and a half. So if you're using the life expectancy tables that the IRS puts out for any other reasons, then the life expectancies have been expanded as well. And then the joint and survivor annuities, which are also retirement plans, those are going to be limited the same way other IRAs are. And we're going to be talking about that shortly, about the 10-year rule, unless your spouse is your survivor in that annuity. So what are we talking about here? Well, the way the changes have been made is that if you have an IRA and you leave your IRA to a beneficiary, you have a few options as how the beneficiary is going to get the money. Number one, you can leave the beneficiary as an outright beneficiary, meaning you leave it in their name, and they will then start taking the IRA after your death. The new rule requires that they take the IRA within 10 years after the participant's death. So basically, by December 31st of the 10th year, 10th anniversary of the participant's death, the IRA needs to be completely withdrawn. Now, the good or bad news is that the beneficiary doesn't have to take the money out in installments. They can take out just required minimum distributions. They can take out however much they want to take. They can take it all in year 1. They can take it all in year 10. They can space it out. The reason why that's important is that if it's a non-Roth IRA and it's a pre-tax IRA, it means that income taxes need to be paid as the money is pulled out. So depending on how old the beneficiary is, if they're still in a low tax bracket, they may want to take it earlier. And if they want to stretch it out, they can also stretch it out, but it only goes to the 10 years. That's different than the old rules where they potentially could have stretched it out over the life expectancy of the beneficiary. So from a participant's point of view, from an estate planning point of view, we always wanted to try, if possible, to stretch out the IRA for longer, not just for income tax purposes, to spread out the income tax, but also to keep the beneficiary from getting all of the money in such a quick period of time. So we used to create trusts and have the trust stretch it out, and therefore the trustee would be in charge of doling out the money. And there were two types of trusts that were mostly used. One was the conduit trust, which basically says if you have a beneficiary of a trust that is getting an IRA, you usually had one beneficiary. The trustee or the trust would stand in the place of the beneficiary, receive the required minimum distribution, the RMD, and then pass that RMD out immediately to the beneficiary. So the trust and the trustee were merely a conduit. That was a simple way to do it. And basically that would go through the income tax of the beneficiary, and that's the way it worked. The see-through accumulation trust was basically where it was accumulated, the funds were accumulated, it did not have to be paid out directly to the beneficiary, And now those trusts are more for the eligible designated beneficiaries, which we're going to talk about in a moment. There were also trusts where you had multiple beneficiaries, which can be disqualified as IRA trusts unless they separate into separate trusts for each beneficiary at the participant's death. The reason is we always have to make sure that the IRA really only has one beneficiary so we can see whose life expectancy we're dealing with and the period of time that's going to be applied to it. So you'll see when there's minor beneficiaries, there's some other rules for it. So you have to have one beneficiary per trust in order for it to work. And then if you have the eligible designated beneficiaries, we have a couple of rules that might be a little bit better. The best beneficiary that you can have for an IRA now is the surviving spouse. The reason being that the surviving spouse can stretch the benefits out in the spouse's lifetime using their life expectancy. And in fact, if the spouse rolls it over into their own IRA, they don't even have to take anything out until they reach age 72. So it's even better than a stretch because they don't have to start taking. With a stretch IRA, you had to start taking out immediately, except that it was over a longer period of time. You can also potentially leave your spouse the IRA in a trust, as long as you're being very careful about the rules with the trust so that you can benefit the most you can from a spousal beneficiary of an IRA. There's also rules regarding beneficiaries that are less than 10 years younger than the participant. So those can potentially be used as well, and we're going to talk about that afterwards. The minor child is a very interesting nuance that we have in this new Secure Act. So here's what happens. If you have, I already said that you can't use the stretch except for an eligible designated beneficiary. A minor child is considered an eligible designated beneficiary. However, it's only for a short period of time. So here's the way it works. If you, as the participant, have a minor child, and this is only your minor child, it can't be somebody else's minor child, it can't be your grandchild, only your minor child when you die, so when the participant dies, the IRA can be stretched out based on the child's life expectancy, thereby doing required minimum distributions in very small doses, starting after the participant dies. And then when the minor reaches the age of majority, it's then another 10 years. So you have a partial stretch, but then it's going to be 10 years and it won't matter what their life expectancy is. So there's a lot of question right now on this as to what does age of majority mean. It goes state by state. So for most states, it's going to be 18, and therefore you have to figure that the minor will have a full payout of the IRA by age 28. But there are some other little rules that come into this where there's not that much clarification. The code says something about it can stretch a little bit longer as a minor for completion of a specified course of education. Nobody really knows 100% what that means, but regardless, it could never go longer than 26. So the way we figure it is the longest you can potentially stretch the IRA for a minor who was a minor at the time of the participant's death is maybe to age 36. So that would be 26 plus another 10 after that. We're going to wait for the regs to qualify and clarify what that actually means and see how that actually plays into the planning. You can also leave minor child a trust and use that trust to get the IRA distributed. Now, the reason we want to use trusts is for stretching it out in terms of payouts, but also we want to make sure that the child is not getting too much money in their hands. And if they're a minor, then there's issues about guardianship, that the money may need to go to a guardian. So if you leave it in trust, it makes it a little bit easier on whomever is receiving the money for the minor, so that the money can be used for the minor's benefit and it doesn't go into the minor's hands. So what is a required minimum distribution? So the required minimum distribution is how much someone has to remove from an IRA in a given year. That RMD might apply to the participant if the participant is alive and starts taking RMDs, or it'll be to the beneficiary either directly or indirectly through their trust. The required minimum distribution is calculated based on life expectancy of the participant during the participant's life, and after the participant's life, it's going to be guided by the beneficiary themselves. So under the old rules, it was a required minimum distribution to the participant if living. They could start taking it at age 59 and a half. They had to start taking it at 70 and a half. That rule is now extended to 72. And this means that when they reach that age, whenever they're going to start taking out, you look at all the IRAs that they have collectively and come up with a collective amount that they have in IRAs. You then look at the tables for figuring out life expectancy and you divide the amount by the years that they have to take it. And that's how you figure out what each year removal has to be, the required minimum distribution, which, by the way, they don't have to take from a single IRA. They can take from multiple IRAs just as long as it adds up to the required minimum distribution. The IRS feels so strongly about this that there is a severe penalty for not taking out enough from your IRAs. There's actually a 50% excess accumulations tax on anything over what you didn't take when you were supposed to take it. So you have to be very sure what your RMDs are. Your financial advisors are usually happy to calculate these for you, but be absolutely sure what you have and how many IRAs you have and what they're valued at, because each year the calculation is different. So don't think just because you took in year one thing, that in year 2 or 3 it's going to be the same. It's not. It has to be recalculated every year. Most people wait until the end of the year to do this, but you may want to plan a little farther ahead to make sure that you don't run into that penalty, because obviously it is rather a severe penalty. So you calculate, as I said, based on December 31st balance, and then you get the RMD taken out. We talked about there's different life expectancy tables depending on who the beneficiary is or who the participant is as to what tables we're using. The tables change. As I said, they've just gone up. So you want to make sure you're always using the right table, because the consequence of not using the right table is the RMD is not calculated properly, in which case there's that excess penalty. One of the interesting eligible designated beneficiaries, and I feel like we must have missed a slide here on the eligible designated beneficiaries, is the special needs beneficiary, the disabled beneficiary, and the chronically ill beneficiary. A chronically ill beneficiary is somebody who is basically qualified under the 6 activities of daily living test that they can't do at least 2 of those activities. Those activities are eating by themselves, going to taking care of their bathroom needs, transferring from a bed to a chair, bathing, dressing, and continence. So if they can't do at least 2 of those, then they can be considered chronically ill. And that's very important because that is an exception. That is an eligible designated beneficiary. That's an exception and allows for a stretch of the IRA. The disabled beneficiary is generally somebody who's already receiving benefits from the government, like Social Security income or possibly Social Security disability income. So when you have somebody who fits into the chronically ill or the disabled beneficiary criteria, then we're able to stretch the IRA. That is a exception under the Secure Act. And what we usually do here is we usually try to use a special needs trust created, and sometimes multiple special needs trusts created for these types of beneficiaries, because generally they're not allowed to have more than a certain amount of money in their name. And if you left them the IRA directly, that would disqualify them for benefits, and that's a huge, huge problem. Most of these people need their benefits. Their benefits are only available to them if they are qualified as receiving SSI, and it has nothing to do with the wealth of the family. It has to do with the beneficiary itself. So the beneficiary can be qualified even if their family is wealthy. If they fit the qualifications, they can qualify for SSI, which opens up many avenues of options available for them and services available to them that they would not have had and would not even be able to privately pay for if they could afford. So you never want to interfere with benefits that are already being received. So you might want to set up these special needs trusts, and the special needs trusts allow for a trustee to be able to not only just distribute, but pay for certain things for the beneficiary out of the trust rather than the beneficiary paying for them out of the meager amount that they're permitted to have. Special needs trusts can be set up actually by the disabled person. That's a first party trust, and there are some limitations there. And the best time to do it is to do it by a third party, which is anyone but the disabled person, who can set it up for the benefit of a special needs beneficiary, of a disabled beneficiary. So when you have the special needs trust available, anyone can actually use that special needs trust, that third party trust, to distribute IRAs to that same beneficiary. So let's give an example. Let's say a parent sets up a third party special needs trust for a disabled person who's receiving government benefits. Well, now that we know that there's only a few beneficiaries that qualify for the stretch IRA, so the disabled, the chronically ill, the spouse, a person who's 10 years or less, under 10 years younger than the participant, and the minor child, then we now need to do some real a new thought process for our estate planning, and maybe the grandparent wants to leave the IRA to the disabled beneficiary and then allocate other sums to the other beneficiaries. That way it can be stretched. So by having this special needs trust in place, you're allowing others to use it in part of their estate plan. We're going to have a webinar on special needs trust later in the year, but I just wanted to throw this in there because it's a very interesting interplay between the IRAs and the Secure Act and the special needs and disabled beneficiaries. So we're going to see a lot more planning of that, where we're going to see the IRAs reallocated to go to disabled beneficiaries. With regard to changes in the age requirements, we've already kind of covered this. We went from 70 and a half to 72, which is actually a nice increase. It hasn't been increased in decades, if not longer. I didn't really talk much about the Roth IRA, because the Roth IRA, the stretch is not as important for the Roth IRA because of income tax purposes, because I said the Roth is after-tax money. So when the money comes out, there's no income tax on it. Where the Roth benefits from the stretch is not only because we don't want the beneficiary to get the money so quickly, but it also benefits because you're accumulating tax-free in the Roth. So the assets can grow, and the longer you can stretch it, the longer the IRA money can grow tax-free. So that's why the Roth also has an interplay with the stretch. It's not as tax intensive as the traditional and the simple IRA, but it has the potential for growth, which is a good thing. And many people have converted their regular IRAs to Roth IRAs and have paid the income tax on it with the expectation that it's going to stretch, and that's now off the table unless it's an eligible designated beneficiary. So what do you need to do? Well, oh, wait, I'm sorry. Let's quickly go through some other changes. Number one, we're now allowed, a parent can actually withdraw from an IRA without penalty $5,000 per parent, so up to $10,000 per birth or adoption of a child. So that's a new thing that we're allowed to do. Because before, if you withdrew any money from your IRA pre-minimum age, which was pre-59 and a half, there isn't penalty assessed to it. So there'd be no penalty here. They also changed some of the 529 plan rules for education. One of the things that they said is you're now allowed to use, if there's money left in your 529 when the beneficiary of the 529 graduates, was always a question of now what do you do with that money, because it's only allowed to be used for certain purposes, otherwise there's a penalty. Well, you can now take up to $10,000, but only that's the collective amount to pay down student loans. And I think that's actually a good policy, because we are having a lot of problems with paying down student loans, and otherwise that money would just sit there and nobody would be able to pull it out without penalty. So this is a good thing. In addition, it used to be that if you were a part-time employee, you couldn't contribute to a 401k, but now if you qualify as a long-term part-time employee, you can contribute to a 401k. There's an encouragement for smaller employers to set up new IRA and 401k plans. If they have auto eligibility for this, then they get a credit. The employer gets a tax credit. Employers love tax credits. In addition, rather than set up your own plan, small business owners can join together and set up a multiple employer plan, which allows for lower cost and for potential better investments because they have more money to invest with. They have also the pooled plan provider, which allows for employers who are not even in the same business, which used to be the same business, to be able to band together and do a multiple employer plan, or they're calling it a PPP. That won't start until January of 2021. So there's all these little things that they changed. They're trying to get more money into the economy by getting the taxes paid out sooner. And they're also trying to encourage on the smaller business owner, increasing the ability for their employees to participate in plans, and that will increase the retirement money. Obviously, if there's more retirement money, there's less pressure on the Social Security Administration for the Social Security money. So there are some things they tried to accomplish there. The biggest thing that they did was the stretch IRA, minimizing the use of that. They've also increased the final age to 72, and we are allowed after age 72 to continue to contribute to the plans, which is new. It used to be once you started taking and you were 70 and a half, you weren't allowed to contribute anything further to the IRA, but you are still allowed to contribute now. So to recap, there's been a lot of changes, and many estate planning attorneys are out there a little bit panicky because they have to go back and look at all of the estate plans to make sure what types of trusts they set up, whether they were conduit or accumulation trusts, because it may not be the appropriate vehicle anymore, and to discuss with their clients what their main goals for their estate plan are, to see if they have to reallocate and redirect beneficiaries under the IRAs and the retirement plans. The things we have to ask are whether the client has charitable intent, because if you use the IRA with the charity, that's also a great way to do it. There's a certain amount that you can leave, that you can redirect your RMDs even when you're alive to charity, that allows you to avoid the income tax on that particular withdrawal. So there's things to do there. You may want to leave your IRA directly to your charity and have other assets go to the other beneficiaries now because the stretch is limited. If you have a spouse, that's really the biggest interplay that you can have, because you have a lot more benefits when it's a surviving spouse as to how to play out the IRA rules. And then, of course, as we talked about with the disabled and chronically ill beneficiaries, you can use them for the stretch. Now, one thing I want to throw in there on that disabled and chronically ill is that just because somebody is receiving government benefits today doesn't mean that they may be disqualified at a later date. So that has to be considered in this as well. Although once you have the designated beneficiary and the participant dies, there may not be much you can do to change it. With that said, one other thing that we should do, and it's in the trust slide, I didn't really go into it, is every trust should have a trust protector provision in the trust. And that trust protector should have some latitude to change trusts into special needs trusts, to establish special needs trusts, and potentially to reapportion certain beneficiaries on the IRA. There are some tax rules with that, so you want to be careful who that trust protector would be. They should not be a family member. They should qualify as an independent trustee under the IRS code under 672. So you want to make sure that the trust protector is a fiduciary, and they would otherwise be qualified as a disinterested trustee or independent trustee if you're going to use them and you're going to give them latitude. But putting that provision in your trust is going to be very helpful potentially down the road, because you never know what laws are going to be changed, and they can potentially help to change things even after the trust becomes irrevocable. So you want to make sure you speak to your CPA this year, speak to your estate planning attorney this year, because if you had any IRAs or retirement plans as part of your estate plan, you may need to change what you have in place at the moment. And the last thing I would say to you is always make sure you know who your designated beneficiaries are. Don't leave it up to chance. Don't leave it to your estate. Make sure you have a designated beneficiary. Make sure your estate planning attorney knows who it is, so that as rules change, you can be kept in the loop and know whether or not you have to make some changes. I want to thank everybody for being a part of today's webinar. If you have any questions, and I see one just popped up, not really specific to this webinar, I will address that separately. If you have any questions, please feel free to send us an email. And if you are interested in a preliminary complimentary consultation, we're always happy to hear from you and set that up. And make sure you're on our weekly newsletter. And our next webinar is on February 20th. The topic is still to be determined. It will be at noon Eastern time, and it will be some sort of asset protection topic. Thank you so much for participating today, and I will be speaking with you soon. Thank you very much.